back to the House Judiciary Committee, and we have version draft number 1.2 of S12 that incorporates some of the changes that we discussed, not last week, but the week before last. And Michelle's going to run through the changes. Over to you, Michelle. And maybe close loud out there.
Can you guys hear me okay?
Yes. Yes.
Great. So for the record, Michelle Childs, Office of Legislative Counsel, and I'm going to share my screen, pop it up for you guys. Oh, well, let me not do that for a second. Let me see what else I got here. I didn't realize I had more than one coming up.
Yes.
Yeah. We're live.
All right, here we go. So draft 1.2. So I'm just going to go over the new changes. I did it as a strike all. I think, you know, everybody loves a strike all, even when the changes are minimal, but because there's a number of changes here and I'm trying to look at it in the context of an individual amendment, I think would be particularly difficult on the floor. So it's a strike all, but there aren't a ton of changes. So I'm going to move directly to the first changes. So I'm going to move to page 15. And this is working with the new language around the process and for the petitions for sealing. And so you'll see at the top of page 15, subsection A is how you go about filing a petition. So there's language that's been added on subdivision 4. I believe that this was one of the there's a few recommendations that came from the Secretary of State's office. I wasn't there for the testimony, but I do have a copy of their memo, and the chair asked that those changes be incorporated into the draft. And I think some of it was around the issue of making sure that the petitioner indicates all the people, all the different entities that may have sealed files relating to that particular offense. And so you'll see there that shaded language on line 16 through 18 is the court is to issue the petitioner an order of sealing and provide notice of the order to all entities provided by the petitioner and all entities required to receive notice pursuant to the specific sealing provision in 7607A. Okay, I'll keep moving unless y'all, it's a little hard to see you on my tiny Zoom screen. So let me just shout out if you got a question, if I move on before you're ready. So related to that change, we're going to move on to section 7607A. And so that reference that we just talked about on page 15 also links into this provision on page 24, which is that when there is a sealing order issued, then the court sends a copy of that order to all these various entities, VCIC, arresting agency, and any other entity identified by the petitioner. So that highlighted language on line 7 is new. Okay.
So a quick question for you on that one, Michelle. Does that language on page 24, should that be matching what the language is on page 15? Where it's saying all, you know, it's also entities required to receive notice pursuant to subdivision.
But that's the subdivision.
Oh, there we go. All right, thank you. I guess I was a step behind us.
It's okay.
Right, go ahead. Thank you very much.
No worries at all.
Thank you.
So that's just the earlier one is a pointer to the section we're looking at right there.
All right, thanks.
Sure. Next we're going to move on to everybody's favorite subsection, which is 7607C on the exceptions to sealing. So we're looking at page 25. So on the exceptions, I just wanted to remind everybody about the intro language for the exceptions, which is that, so in all instances, unless it's specifically identified, a party that's seeking to use a sealed criminal history record in a court proceeding, so in a public proceeding, right, shall, prior to any use of the record in open court or in a public filing, notify the court of the party's intent to do so. And then the court determines whether the record may be used prior to its disclosure in the proceeding. So there is an exception to that for the provisions in subdivisions 1, 4, and 7. 1 being that if the entity or person is using the record in continuing litigation, and subdivision 4, I'm just going to scooch down, is around for a DUI, and then subdivision 7 is when you're using it for purposes of discovery. So the first change with regard to who can access a sealed record and when they can access a sealed record is in subdivision 1 there. And this is just tweaked slightly. And this was trying to address concerns that were raised by the Attorney General's office around using a record that they possess for any litigation or claim that's arising out of a particular incident. And also to be able to use that sealed record in anticipation of any litigation. So I think that, you could read the existing language to kind of cover those issues, but my understanding is that there's been kind of a lack of clarity in terms of how the court is interpreting that. And so there's this is just expanded a little and clarified. Okay.
Yeah, go ahead, Nate.
One quick question, Michelle. What was so in page 25, line 13, we're adding an entity or person, and then again a little later. Why are we adding that or person? Entity doesn't kind of cover it all.
I would have to. I'm trying to remember.
I can.
I think if I'm looking at it, so I'm looking at Todd's kind of notes around it, and he said he recognizes that it's redundant, but because the AGO operates as a legal attorney for state entities, as a private, and they're not choosing the representation as a private individual would, they wanted to make it clear that they could access the entity's records. So, I don't know if that helps or not.
So it's a little redundant. It does help. Sorry to interrupt you.
Sure, no.
I just think that if we're going to have the redundant language in that subsection, then I would probably want to have that redundant language in 7607A and on page 15 when we're just talking about entities or persons. So we have here all entities provided by the petitioner and all entities required to receive notice pursuant to subsection 7607A.
Yeah.
And we've got
Yep.
the same thing.
Yeah, that makes
Okay.
sense.
Okay.
Sure. Yep.
Thanks. Good catch.
Sure. So subdivision 2, this is access for criminal justice agency. And so this is reverting back to the language that was in what the House passed last year. So getting rid of the, petitioning the court to access those records, going back to criminal justice agency can use those sealed records for criminal justice purposes. I think I defined criminal justice purposes again, and yeah. So I'll make a little in the next version, I'll make a little tweak to this because we cite to this one, which is the same, but I also put it in this section. So I'll make a decision one way or the other so that it's a little clearer, because you don't need to, if you have it in this chapter, you don't want to cite to the Title 20 provision.
So essentially what we're doing is taking away the petition to access My understanding is that some of the witnesses wanted to change that to a petition for use, but that essentially is already covered in C,
Correct.
where they have to give notice to the court if they're going to be using it. So it seemed like that would also have been a little redundant. So anyway, okay, go ahead.
Yeah. Next change is in subdivision 3. So this is, you recall that so there were the provisions in the Senate proposal where you had, criminal justice agencies would petition and they would have a certain standard, then defense attorney could petition, they would have a certain standard to show, and then the other one was law enforcement could use in exigent circumstances. So in terms of criminal justice agencies and law enforcement now is just kind of sucked up in that definition of criminal justice agencies and can use for criminal justice purposes. So they have broad authority to access. So they don't need that exigent circumstances. That's out. The defense attorney, so it could be that a defense attorney is part of the Defender General's office and they qualify under this broad provision in subdivision 2 for criminal justice agency, I'm presuming, because 50% or more of their services are fit into that category. But this provision at the top of page 26 for subdivision 3 is a defense attorney who's not covered by subdivision 2, then would apply to access to sealed criminal history record by filing a petition. And so it's that same standard that the Senate set out. I don't know whether or not, from a policy or legal perspective, thinking about whether or not a defense attorney is part of the DG's office or not part of the DG's office, whether it makes sense for you necessarily to have two different standards in terms of access. But I just note that is that there could be under this kind of structure, you can have a, a defense attorney who is within the agency that has a greater degree of access than someone who is a private defense attorney. And that may be fine, but I don't know. But I just wanted to raise that as a potential policy issue.
Karen, before you go ahead, Karen.
This is still on 3. I'm not sure if it matters or not, but I know in the other ones we changed access to use and this one stayed at access. I don't know.
So if you're going to be using it in open court, then you use that intro language that's up at the front that's always been there, where you basically, the court's going to determine whether or not you can make it public. I don't know. This idea of changing access to use, I think just me personally, I'm not a big fan of unless you did some holistic look at all of the record stuff and see where access is used and where use is used. And you really look at all of it and make sure that you're making a policy distinction between those. I'll certainly do whatever you want me to do on that, but there is the provision, there is the language that's up above around a party seeking to use a sealed criminal history record.
Yeah, and I guess I don't necessarily have strong opinions. It'll be interesting to hear if witnesses do, because I also had a note, what does use mean, and just being consistent about that. So I do feel like that might be something for us to address or ask witnesses about so we can be consistent.
I think that's part of my issue is I don't know what use would necessarily mean in different contexts.
Although it's clear what it means as far as providing it in court in or a public file.
Right. Right.
Okay. All right.
So the next change is top of page 27, subdivision 7. This was requested by the Attorney General's office around discovery. just the addition of that I think originally it just said the state's attorney's office shall disclose information contained in the sealed record when required to meet discovery obligations. AG wanted to be added on there, and also make sure that the person who is the subject of the sealed record would also have to comply.
Questions on that one? Nope. Okay.
Subdivision 11, this is just a small language tweak. I think on line 17, it said case records, and Judge Zone, I think appropriately recommended that it say criminal history records and not case records. I think that.
And the same change should be made probably on page 28, line 3.
Yes, you are right. Right. And those came from the agency, which is why, like, sometimes I'll see terms on there and I'm like, why did I say it that way? And I'll be like, oh, I didn't say it that way. I picked it up from somebody else and didn't catch it. So thank you. So I will change that on subdivision 12 as well in the next draft. Next change is in subsection D. I think that this was part of what was requested maybe from the Secretary of State's office as part of just the continuation about who receives notice of the order.
Right.
Next thing, this is not a change here, but I just wanted to clarify. I had spoken to the chair about it, but 7609 under existing law provides for the process for expungement of criminal history records for a person who was 18 to 21 years of age at the time that they committed the offense. And it was my understanding that and what this amendment does, and it's not changed from the previous version or the version that passed the Senate, is that it just kind of restructures the section to make it a little easier to read, and then changes expungement to sealing. But it was my understanding that the Defender General's office testified that what you were doing here is changing it from an automatic expungement to a sealing via petition. That's not my reading of it. And I confirmed my reading of it with the court that it is currently by petition, so would remain by petition. But you are just changing it from expungement to sealing, because right now, if you look at the language that is at the top of page 33, current language, it talks about the person may file a petition with the court requesting expungement. And so I don't know why there's different interpretations from different agencies, but I feel confident that the current process is by petition, and it really kind of only makes sense that it be by petition because the court would have no way of knowing otherwise when that person completed the requirements of their sentence. So no changes to that section. I just wanted to kind of circle back to it. The next change is on page 34, section 2. This is new it was not contained in the Senate version, but it was in what the House passed last year. So you'll recall deferred sentences. Under current law, those records, upon successful completion of a deferred sentence, those records are expunged. The Senate chose to keep expungement for deferred sentences, but what you have in your proposal right now in section 2 is to switch it from expungement to sealing for successful completion of deferred sentences. There's no other substantive or policy changes in that. It just changes it from expungement to sealing.
All right.
And I think that's the last one.
Excellent. So we're going to be having all sorts of good testimony in the next couple of days on this. Just a couple quick things just to put on your radar. But first, Karen had a question.
All right, and this might be to my colleague Ian. I'm just looking because as I was sealed and expunged are not needed.
Yeah.
Is that included in this, or is that?
That makes sense. you can circle,
Back with Ian?
well, and Michelle for, I guess, update this. Yeah, I forgot to pass that one on, Michelle.
Okay, I'm sorry, can you explain that a little bit? I don't think I had heard it before. So, or do you
All I
want to
had,
send me a
so
little
Glenn
something?
remembers it better.
Go ahead, Ian. Oh,
Michelle, it just came up when we took a lot of testimony from agencies, like professional, conduct investigations and all these things. And one of the things that came up a number of times was just like in these forms and things that they fill out, a lot of people were accidentally disclosing that they had sealed records when they were being asked, do you have a record? And that they were saying, well, we just ignore it because we're not supposed to look at it. And so I was wondering, could we just write something in, or I wanted to know what the process could be so that we could try to address that by saying in these forms, hey, if you have a sealed record or an expunged record, you don't need to disclose that you have a record because you don't. And I think what we got to in the committee was that that could be language that was written into here somewhere. So that's actually in statute.
so wouldn't be in the Green Book session law possibly. Or maybe it's not session law, I don't know.
I don't know either.
Okay, I feel like because I wasn't there during this discussion of it. So it's that, and I think what I would need to know is what circumstances do you want to be telling people that they don't have to disclose? Because in general, you have on the effective sealing that information is not disclosed. So I would want to understand the specific targeted thing where people are incorrectly disclosing records and.
Yeah, I don't want to interrupt. Sorry.
No, that's okay. Just so that we're just saying you shall not, if you are X, you shall not disclose sealed records under these circumstances.
So I think the idea is that any we would be instructing state agencies. It wouldn't be instructing anybody. It'd be any state agency that has a form asking if somebody has a criminal record that they need to add to those forms that whatever that language is.
Just that, if you have, because we're basically.
I get it.
Like it or not, we're saying that a sealed record is an expunged, or is the policy we should be moving forward towards, which is like having it sealed, not expunged. So I don't want people getting confused on at least state forms when we're asking them whether they have a criminal record, to have them confuse and disclose a sealed record when they don't need to. So at least in this one sphere where we have control, we can at least clarify for people that they don't need to disclose a sealed record.
Okay, so you're talking about the people who are the subject of the record, not about the.
Yeah.
Okay,
And
right.
I apologize.
I didn't understand that. So you're
I wasn't
talking
being
about
clear.
that when the state is asking people if they have a record, they have to be clear, a record that is not sealed or expunged.
Yeah, and I think what I heard even was like on some of these electronic forms, it just is like a yes or no button, and above it is like, do you have a criminal record? And I think in parentheses, it could just say something like, if you have a sealed or expunged record, that is not a record, you don't need to disclose it here, something like that. And that being present on all state forms.
Okay, the issue I would just raise is that I think that there are some areas where people do need to disclose that for certain circumstances, like the CDL people or I don't know, but I know that there are certain types of professions just from in the past that people do, but maybe I'm wrong. Maybe you got different testimony about that, but if you didn't, I'm happy to go with that. It may have changed.
I just think to my own experience, like thinking if I had a sealed record and I read on a document that was coming from the state that said, do you have a criminal record?
Sure.
I would pause.
Right. Yep. Understandable.
I do. Right.
Okay. I'll add something and they'll run it by you.
So the other thing is we may want to see the language in diversion where it says expunged and have it changed to sealed. I mean, I don't know if I really want to put it into the field quite yet, but I think because we're gonna have somebody coming in, a couple people testifying on that, it would probably be handy for us to have that language.
I can just send the citations to Nate, like the links to the existing, is that what you're talking about? Like to
Um,
existing law? Or you want or you want an amendment that changes everything to look at?
I think the latter, kind of looking about that is, which hopefully it's not.
When are people
But-
coming?
Oh, I think it's Wednesday.
Tomorrow?
No, wait a second.
Yeah, it is.
No, wait a second, let's see.
So what's tomorrow? Yeah.
Yeah, but that's not on this issue. So I could move Willa to Thursday. In fact, I think I probably, well, do you know how busy the floor is supposed to be tomorrow?
I'm not very busy.
Not very busy? Okay, well, then we probably want to keep some of these folks on. I mean, if it need a little more time, I can change those witnesses to be on Thursday morning. Would that possibly work? Let's see.
Yeah,
I'll change it.
I don't think it's happening before tomorrow morning.
Right. Yeah, no. So yeah, I'll move those witnesses to Thursday, and if that happens, that'd be great. If
Okay.
not, we'll base it on the other issue. The one other thing, and this is, I'm not going to ask you to do anything on this one, but I just want to flag this for people in here to think about, and this is something that I'll be asking witnesses for. You know, we are moving away from the restrictions that the Senate imposed for accessing sealed records. And last year, we went to this 10-year so-called super seal. We hate that terminology, but in any event, but so we're removing that, and I anticipate some pushback on that issue. And I'm going to ask individuals what could make this work. And the whole trade-off for the whole bill is to get more offenses that can be sealed so people can say they don't have a criminal record. And I'm going to suggest and ask various witnesses that what if we move to changing the felonies that can be sealed to any felony with the exception of the big 14 and the listed crimes. And I'm going to put that, before various witnesses, because that may need to be the trade-off if we want to have really essentially unrestricted access for criminal justice purposes. Just want to put that out for people to think about. Because that may have to be something that is a give and take on that. So we'll ask witnesses that. So that was nothing really for you, just kind of
Okay. Can I ask one more question just to back about the changing diversion from expungement to sealing? Is there anything that you are have been working on this year that's in, like moving along that I would need to look to
No.
other than just amending existing statutes? So the TASP bill or any of that stuff?
No, nothing's changed in any bills on the diversion. This year.
Okay. Okay.
I ask one other
Yeah, please.
very brief question on the language. Michelle, sorry, just looking back at page 27. Is the language that the AG asked for on line 2 of 27 and 1 and 2? So the person who is the subject of the sealed record and the attorney for the person who's the subject of the record. So we're adding those two individuals in along with the AG and the state's attorney. Is that for like civil context, or what is? Do you know what that was for?
Checking my notes. I have something in here from him, but I would say, I'm guessing Todd's going to come back in. I don't want
That's
to.
Todd.
Yeah, I would say it'd be better. They did give kind of an example of a particular case where they had trouble accessing. But I think it'd be better for him to maybe present the issue to you because he does raise it in the context actually of a criminal case.
Oh, interesting. Okay, cool. Yeah,
Mhm.
that's Todd. Thank you.
Yeah.
Okay. All right, thank you very much, Michelle. I appreciate
Okay.
it.
All right.
So we